Good afternoon, everyone. We have a great program scheduled for today. I am going to take a few minutes now to go over the agenda. In a few moments, I'll turn the program over to one of my colleagues in our Albany office, Roger Bearden. Roger will be discussing a decision out of the Albany Supreme Court last week, where the court overturned hundreds of millions of dollars of fiscal intermediary rate cuts implemented at the direction of the State Department of Health. Next, we will have Mark Saracino from our Melville office. Mark's a new presenter on today's webinar, and we're fortunate to have him with us. Mark will be providing us with an update on the state of non-compete agreements in New York. And then last but certainly not least, we have Kate McClung from our Rochester office. Kate will be discussing new guidance from the EEOC on discrimination related to DEI, diversity, equity, and inclusion. Okay, I will now turn it over to Roger for his update.
Thank you so much, Carrie. And for those of you, we'll get to this on the last slide, but there's going to be a webinar tomorrow, which will go fully into the ins and outs of this for folks in the industry. So the hope here is to just highlight a couple of those elements as may be relevant to really any regulated entity doing business in the state of New York. So if we could go to the next slide. So I just wanted to highlight for folks that may not be aware of it, we have a government and regulatory affairs practice based in Albany and throughout the state of New York. And we do a lot of work in conducting administrative advocacy, legislative, regulatory advocacy, and where necessary, litigation to support our clients. This happens to arise out of the healthcare context, but it's certainly something that we do in many contexts. So I want to go to the next slide, please. So the case that we're talking about, a case that BSK brought last summer, and it came after the New York State Department of Health did a very unusual thing. So it changed the reimbursement rate for what are called fiscal intermediaries, which are Medicaid providers who provide consumer-directed personal assistance services. And those services are home care services that allow people to live in the communities of their choosing. Those services have been quite a bit in the news because of other changes that have been made by the governor and the Department of Health, which are of great political and legal significance. But these changes had to do with the change in the way those providers would be reimbursed. And when I say the Department of Health did something quite unusual, is it changed these rates by PowerPoint presentation. And so what it did is it called together what are called managed care plans to a meeting and gave them a PowerPoint and said, change your contracts with providers to both change the way that the payments would happen as well as the amounts. Several $100 million of rate reductions were the intention here in order to squeeze some money out of those providers. We initially, as I said, attempted some administrative advocacy to have the Department of Health reverse its view, which was unsuccessful, and we brought litigation in Albany State Supreme Court. And for those of you who know, State Supreme Court is, for reasons of history, the trial court in New York State. And typically, when you are challenging regulatory, or in this case, the lack of regulatory action, Albany State Supreme Court is a pretty good place to go. So what we did is we challenged in that court under the State Administrative Procedure Act, and we argued that when you're making as government a rule that applies across an entire industry without exceptions, without discretionary decision making, then the State Administrative Procedure Act requires publication in the state register, notice and public comment, evaluation of the comment, and then final issuance of the rule. Have to analyze its impact on regulated entities, a series of requirements that are in the State Administrative Procedure Act. And the state did none of those things, and took the view that it could unilaterally amend its contracts with these managed care plans because it had contracts and that the rulemaking process was not applicable. So the court, in the decision that we are talking about in C.D. Payne's et al., the McDonald et al. C.D. Payne's is the Association of Consumer-Directed Providers in New York State, and then in the litigation we also represented a set of individual fiscal intermediaries. The court said, well, if it's a fixed general principle to be applied across an entire set of providers or across an industry, that's a rule, and you had to follow SAPA. So it declared in a decision that issued on Thursday that new rate making to be null and void. I'll go to the next slide, please. And so, as I said, the Department of Health had made the argument that it could unilaterally modify the contracts and that it could do so outside of the requirements of SAPA. So that's a very important ruling that the court had, not only for this particular industry and for any really Medicaid-funded industry where the Department of Health might seek to amend its rules without going through the correct process. I also wanted to highlight for this audience, which I know is an audience that has some healthcare entities and entities across various industries in New York State. There's a strong importance to this decision for any executive agency action and the need to follow SAPA. And there is an unfortunate tendency that has happened over time in state government where those kinds of rulemakings are seen as inconvenient. And you'll see memos, you'll see letters, you'll see directives, you'll see everything other than a rule. And those things are not the way that state law demands that executive agencies and administrative agencies conduct their business. The next slide, please. So as I said, there's a webinar tomorrow focus on the implications of the decision specifically for providers in this entity. They have a lot to do now in terms of figuring out how do they get the benefit of this decision in terms of the hundreds of millions of dollars of reimbursement that they're now owed. We have a web link, which is probably not useful on a webinar presentation here, but if you go to our events page, you can find information, and please feel free to sign up. And happy to throw the mic back over to Carrie, and if there are any questions, to address them or let the next presenter go.
Thank you, Roger. Yeah, I don't see any questions, but as Roger mentioned, he'll be hosting a separate webinar tomorrow focused on the implications of this decision. So if you are interested, we would encourage you to attend tomorrow's webinar. Okay, next up, we have Mark to discuss non-compete agreements. Mark, thanks for joining us today. I'll turn it over to you.
Yeah, thanks so much, Carrie, and thanks, Roger. So my name is Mark Saracino. I'm an associate in the Melville office. I'm in the M&A group. There's a lot of overlap between the M&A group and the business transactions group. So that's what I focus on. Today I'm going to be speaking about non-compete provisions and enforcement in New York specifically. It's been sort of a hot topic over the last couple of years, specifically last year when the FTC sort of came out with a major ban or attempted to ban non-competes pretty much nationwide. So we'll touch on that a little bit later in the PowerPoint, but Kathy, you can go to the next slide. So I know we don't have too much time today, but just to dive into the, sort of a high level overview of non-competes and sort of the status of where they stand today. So we'll touch on just the scope of what a non-compete really is, some New York factors that the courts have been looking at specifically over the last few years, and some recent developments, some bills in New York that are on the table right now, and some case law. You can go to the next slide, Kathy. All right, so I think most people have probably come across a non-compete or have at least heard of this type of provision. In my group, we focus more on drafting them for contracts, and and sort of analyzing them for clients, which is sort of separate from the litigation aspect to it. But there, as you know, there's a lot of overlap there. Based on how people like me or people on my team draft them, will have huge consequences for how they're interpreted in court. So really, what a non-compete aims to do, it's aiming to prohibit or prevent somebody from competing in a particular industry over a particular period of time in a particular geographical landscape. And those three factors play a big role in how they're interpreted in court and whether or not they need to be modified. But the general theme is that, and this is the second bullet point, where, it's aiming to protect legitimate business interests. So employees, for example, they have access, especially high paid or high level executives, they have access to information about the company, proprietary information, confidential information, trade secrets, how the company operates, how it structures its bidding process, for example, how it's structuring its pricing mechanics. So there's a lot of information you can get from working with the company, or just through a general business arrangement with another partner, which would place you, or which would give you an unfair advantage after terminating that relationship if you were to go up and open up shop on your own. So the key behind the non-compete is just to prevent employees or people in positions where they have access to confidential information to not put them at an unfair advantage. That's really the gist. And if you're looking at contracts specifically from an M&A perspective, you'll see usually sections that are titled restrictive covenants, and you'll have a few pretty prevalent ones. You have obligations of confidentiality, you have non-compete provisions, you have non-solicitation provisions, and you'll typically see non-disparagement provisions, meaning you can't speak negatively about each other. So those are the standard restrictive covenants. Not the non-compete covenant is one of those, but they all go hand in hand. And you'll see this in a variety of different contracts. I mean, the most common contract you'll see this in is employment agreements. But from an M&A perspective, you'll always see them in the purchase agreements. When if somebody's spending $1 million, $2 million, $100 million to buy a business, they don't want the principals or the owners of that business the next day to say, "Oh, thanks for the money. Now I'm just going to open up shop down the road, start really doing the same thing I was doing, and take all the clients that otherwise would have gone to you back over to me." So you'll see them in a variety of different agreements, but employment agreements, purchase agreements, partnership agreements are pretty common documents where you'll find these provisions. Kathy, next slide, please. Thanks. So in New York, over the last few decades, they've really, through numerous different cases, they've crafted sort of a reasonableness test, just like many other things in law. That there's a reasonableness test that takes into account a few points, which I list here. So, is it necessary to protect legitimate interest, which we just kind of went over? Who are we talking about? What kind of information did they have, and would they be given an unfair advantage if they opened up or competed after this relationship was terminated? Does it impose undue hardship on the employee, right? I mean, if it's just a 9-to-5 worker, and let's say they work in a particular area that only has, retail stores next to it. Otherwise, the employee might have to travel 50 miles out of his way to go work in a similar type of job or position. Well, the courts will look at that and say, it's not fair to this employee or this person to have to travel so far, or to have to totally, reshift their experiences and just their knowledge base in order to find another type of job. They could have went to school and got a license for something, specific, and it wouldn't be fair to them to have to kind of get rid of that, throw that in the trash and start all over. Does it harm the public, and would it do the public a disservice, or would it benefit the public to have some sort of non-compete in place? And as we talked about earlier, is it reasonable in time and geographic scope? And also, besides just time and geography, is it narrow enough in the particular industry? That's something else that's important. You don't want to just say you can't work in the construction industry. Well, maybe it's a very narrow or a very niche area in the construction industry that you're really concerned about, and that's the area that you want to focus on, and that's what we would recommend you put in the contract, keeping it as narrow as possible. And finally, this last bullet point, blue penciling, you'll actually see provisions in contracts that are titled blue penciling provisions. I see them all the time in purchase agreements. Really, what this provision is saying is that just because if there's ever a dispute over the non-compete and it goes to court, well, that doesn't mean the non-compete is getting thrown out entirely. Well, we'll modify it. We'll allow the court or the judge to modify this to bring it back in the reasonable parameters. So maybe if we put you can't work in the construction industry in the United States, obviously that's very, very broad. A judge might say, look, we're gonna refit this so that it's reasonable, pulling it back from the United States to maybe Long Island, and pulling it back from the construction industry to maybe road pavement services or something similar to that. So there's ways to craft this and ways to modify it so that it will fit within the reasonableness test and it doesn't have to be thrown out entirely. So that's blue penciling. Kathy, next slide. So some recent developments, the FTC rule, which I mentioned earlier, this really was a big factor in sort of the recent discussions surrounding non-compete provisions. Yeah, you didn't really hear much about non-compete provisions. It wasn't really such a popular thing. And then once the FTC came out with this rule back in 2024, it was, there was so much conversation surrounding non-competes all of a sudden. So really what the FTC tried to do was issue a sort of nationwide ban on non-compete clauses. And as you would guess, it faced immediate, sort of legal challenges. And I believe there were a few, I think there was a Texas federal judge, there was a Florida federal judge, and even I believe a Pennsylvania federal judge that came out issuing orders against the FTC's final rule, with the Texas federal judge issuing a nationwide injunction. And that's currently in effect right now. They're appealing this, but as we speak, there is a nationwide injunction against this final rule. And alongside that, with the new administration in office, they're making a lot of changes, as you know, with different governmental agencies. And Linda Khan, who used to be the FTC chairperson, she resigned. There was a new appointment by President Trump, Andrew Ferguson, and just recently, I believe just a couple of weeks ago, 2 additional Democrats were removed from the FTC. And so the overall thinking there is they may not even pursue this rule anymore. They might drop the challenges in court, and this rule will basically be fully reversed. So that's where we stand with the FTC rule. And Kathy, if you can go to the next slide. And then just to touch on some New York developments, there seems to be an opposite trend with New York developments with federal. As I just mentioned, on the federal side of things, they seem to be reversing at the FTC rule and really, allowing non-compete provisions to be enforceable and in contracts. New York, on the other hand, is becoming more and more stringent and scrutinizing these provisions. In 2023, the Assembly introduced a bill. It went through the Senate. It got to Governor Hochul's desk, and that was a complete ban on non-competes in New York. She was a little reluctant to go through with a complete ban, so she actually did not sign that bill. But they just introduced a new bill in 2025, which aims to definitely regulate non-compete provisions, just not as stringent. There wouldn't be a statewide ban on non-competes. There would have to be certain factors really for anybody earning under 500K. If you are not a healthcare worker, and their severance included in the non-compete, well, those are the factors that the courts are now looking at, and those are the factors that this bill would be looking at as well. So I know I'm running out of time here, but these are the recent developments. Kathy, I think there's one more slide. Yeah, so we won't go too in detail with this case, but this was a very recent case in the Second Circuit that was relevant to non-compete provisions. There was the main theme with this case was antitrust, but there was some underlying themes of non-compete. Essentially, Goldman Sachs Fifth Avenue, the retail store, entered into a no hire contract with a few other major retailers, Gucci, Louis Vuitton, basically saying, we're not going to hire your employees, you're not going to hire our employees. And a lot of times this will happen because there's some quid pro quo. We're going to be your exclusive provider of these shoes, but we're not going to hire your employees. And basically, long story short, there was a class action brought by the employees, really an antitrust suit, but they also made the argument that it was basically a de facto non-compete. They didn't sign a non-compete, but by their employer entering into this agreement, it acted as a non-compete. The court basically shot that down and said, no, the company is allowed to enter into no hire agreements. It doesn't present an undue burden on the employees. There was no harm demonstrated. There's other retail stores that you can work at. It was narrow enough. And so that was a recent decision by the Second Circuit in New York. So again, the trend in New York is really they're on a state level, they're being more stringent with non-competes. On a federal level, the FTC, the Second Circuit, they seem to be erring on the side of allowing non-competes. So we'll see how that plays out in time, but that's sort of the current status. And thank you.
Great, thank you, Mark. I know this has been an area in a state of flux over the past few years, so we do appreciate the update and your insights. I will now turn things over to Kate McClung, who will discuss the EEOC's new guidance on DEI. Kate?
Thanks, Carrie. So as I'm sure you are all aware, the Trump administration, after taking office on January 20th earlier this year, issued a series of executive orders targeting DEI programs. And they didn't provide a lot of information about when a DEI program or initiative violates the federal discrimination laws. Now, on March 19th, the EEOC and U.S. Department of Justice issued joint guidance on this issue. And so what they've said is that as far as when it violates federal discrimination law, any employer initiative, policy, program, or practice that involves an employer action and is motivated in whole or in part by any protected characteristic under those federal discrimination laws. They made it clear that this applies to a wide variety of aspects of employment, and that in order to allege a discrimination claim based on DEI, workers only need to show some injury or some harm affecting their terms, conditions, or privileges of employment in some way. So some examples that they gave for disparate treatment, when DEI would be considered disparate treatment. Certainly, obviously, you can't consider protected categories in making employment decisions like hiring, firing, promoting, demoting, compensation or benefits decisions, work assignments and duties. That's no surprise. We've all known that and done that for many years. It also provides the example of access to or exclusion from training, internships or fellowships, mentoring or sponsorship programs, networking, resources. So any exclusion or inclusion in any of those categories based on any protected category under the law would be problematic. That does include leadership development programs that's specifically referenced in the guidance as an example. Another example that they give of disparate treatment discrimination by DEI programs is the selection for interviews, including the placement on or exclusion from candidate slates or pools. So one method that a lot of companies have used to try to increase diversity in the workplace is to take efforts to expand their diversity pool by purposefully marketing in areas that they believe, or schools or colleges that they believe will result in more diverse applicants. And so this language and this guidance really calls into question whether that's permissible or whether that would be considered discrimination by the current EEOC. They also clarified that the EEOC does not require a higher showing for so-called reverse discrimination. This issue is currently pending before the US Supreme Court. Some lower courts have found that reverse discrimination, meaning where the person is in the majority group, so a Caucasian alleging race discrimination, for example, and they've set different standards. They've made it harder to bring that kind of discrimination claim. That is currently before the Supreme Court, as I said, but the EEOC in its enforcement guidance is indicating that they don't even recognize that concept. There is only discrimination, not reverse discrimination. Another category that they indicate is problematic under the federal discrimination laws is anything that limits, segregates, or classifies based on protected categories. So if you limit membership in workplace groups like employee resource groups or other employee affinity groups, such as a women's networking group or an LGBTQ group, that would be problematic. You also can't separate employees into groups based on any protected characteristics for DEI or any other types of trainings or any other employment privileges, even if these segregated groups receive the same programming content or same amount of employer resources. This does include any sort of employee-driven activities that are employer-sponsored in some way. And a company could sponsor an employee-driven activity by making company resources available to it. That could be time, facilities, use of the premises, or any other form of official or unofficial encouragement or participation in that employee-driven event. So you'd have to make sure that even if the company is not spearheading this event or this activity, if it's sponsoring it in any sort of way, then it can't be factoring in protected categories in that event. They've also indicated, interestingly, that one form of hostile work environment harassment could be DEI training itself, depending on the content, application, or context of that training. Now, this is particularly interesting in New York State, where we have mandatory annual sexual harassment training. So it's not an option for employers to just say, well, we're just not going to train on this issue to be on the safe side. You have to do training in New York. So it's going to be a bit of a tightrope walk, complying with New York state law and doing your annual harassment training, but protecting yourself against claims that your training is making someone uncomfortable in their work environment based on any of the protected categories. The guidance does specifically note that this does include any sort of unconscious bias training. And they also indicate that opposing DEI training could constitute protected activity, meaning that if there's then an adverse employment action against that individual, that could be unlawful retaliation under the federal discrimination laws. Now, interestingly, they cite two cases in support of their claim that DEI training can create a hostile work environment. One is from 30 years ago. And that one, that there was a male employee who alleged that he was forced to participate in a role reversal exercise at a diversity workshop where he had to walk down a gauntlet with female employees on both sides, and they laughed at him and called him names and touched him, including his genitalia. So fair enough, that sounds like a hostile work environment. The other example that they gave, interestingly, is a case that was actually dismissed by the court earlier this month, but they cite an earlier decision in the case. And that was something that we've seen a lot of in recent years since 2020. You know, the head of the organization sends out an email to all staff about conversation on racial climate and indicating the organization's stance on social justice issues. And then there was a mandatory unconscious bias workshop. And so that made an employee refuse to participate in it, even though it was mandatory, and he was ultimately fired for that. But ultimately, the court held that that was not sufficiently severe or pervasive to be harassment under the federal discrimination laws. So I haven't exhaustively researched this issue myself, but based on the limited case law that the EEOC cited on the issue, it doesn't seem like there's a lot of court support for this issue yet. So we'll have to wait and see how courts interpret this, if they interpret it the same way as the EEOC or not. So I don't see any questions in the chat, but if you have any questions after the webinar is over, feel free to reach out.
Thank you so much, Kate. We do appreciate the update on this. And thank you everyone for tuning into the webinar today. We're glad that you joined us. We have the contact information for all the presenters on this slide here. So please feel free to reach out to any of today's presenters if you have any questions, or myself. And again, thank you for joining us. We hope to see you next week. I will also be presenting or hosting next week. Thanks again for joining us. Take care.